Okay, we've had a very quick look at part 1 and part 2, and I was going to move on to part 3, criminal procedure. Okay, let's have a look at this. So, a typical case. Something happens, the police see it or it's reported to them. The first decision, shall we take action or not? If yes, is the offence a minor one or a serious offence? If it's a minor offence, you are summoned, so they send you something in the post saying you have to appear in the magistrate's court. If it is serious, there will be a power of arrest. The police will have the power to arrest the suspect. Question, is the arrest lawful? I don't know whether you watch films, but you see the English films, I'm arresting you in the name of the law. You are not required to say anything, but anything you do say may be taken down and used in evidence against you. That is a caution, that you have to give when you're arresting somebody. In America, they call it Miranda, the Miranda, the rights of the Miranda case. So, in order to be lawful, you have to give the caution. Then, do the police have the power to detain once they've arrested you? How long before they either have to charge you? It says we are charging you that on this day you committed this crime, or release you because of lack of evidence. Now, the decision whether to charge is taken by the CPS, the Crown Prosecution Service. And it's a two-stage test. Is there enough evidence? And is it in the public interest to prosecute this person? And then, assuming the answer is yes, if you are charged, or the formal term is you are indicted, and it's, as Sarah mentioned, it's in the name of the Crown, and it's the Crown versus, so R for Regina, or with the King, R for Rex, against Smith. Next question, you've been charged. Are you freed on bail, or are you remanded in custody? You're remanded in custody after you've been charged, but before the hearing, okay? Or are you freed on bail? Okay, bail, you understand bail? You're released, but on certain conditions, and those conditions can be that you have to report to the police station once a week, you have to turn up for trial, and also sometimes they say, if you run away, we will take, we will take some money, and usually your friends have to put up the money as bail. Often also your passport will be taken from you, so you can't travel overseas. So as I say, what happens next depends on the offence. In a summary offence, the case starts and ends in the magistrate's court. The indictable offence, the indictment starts in the magistrate's court, but it is immediately adjourned, that word again, it is adjourned to the Crown Court. And in an either way offence, the defendant decides on the forum. You can see there, if you're interested, the rules about the wording of the indictment, because clearly it's important that for the prosecution and the defence, that the indictment clearly states who is being charged, is it one person or more than one person, and what they're being charged with. So those have to be clear. And then the arraignment is what happens when the trial starts and you are brought to the dock. John Smith, you are accused that on the 15th of June 2013, contrary to section so-and-so of the Theft Act, you did take a motor car without the consent of the owner with the intention of permanently depriving it. How do you plead? And what's the answer? Two possible answers. That's right, guilty or not guilty. And if he pleads guilty, that's the end of the case, except for one, perhaps two things. There may be a plea in mitigation, which means I'm terribly sorry I did it, but you know, I had no money and my children needed the medicine and I had to take the money. You know, that's a sort of plea in mitigation. Please, it's against my character. These people will tell you what a good guy I've been all my life. It won't happen again. I'm terribly sorry. That's a sort of plea in mitigation, through which you hope to get a reduced sentence. And then the next thing is the sentencing, which, as I say, the judge will do if it's in the Crown Court. And then, on the other hand, if he pleads not guilty, that's when the fun begins. That's when the trial begins. And it is, there is the presumption of innocence and the burden of proof. It is the duty, well, it is the job of the prosecution to prove beyond all doubt that the accused committed the offence. And they prove that by presenting evidence to the jury. And that evidence will be the testimony of witnesses and also perhaps exhibits. Exhibit A, the gun, yeah? The knife. So some basic terminology. It is alleged and allegation. You often see that in newspaper reports because there are strict rules on what you can say in the newspapers about I won't even call it a crime, about an incident before the trial has finished. And the idea is that, you know, members and potential members of the jury read the newspapers and watch the television. So it might prejudice the defendant's right to a fair trial if you start calling him the criminal. Or, yeah, well, he's done it. Well, he's done it 20 times before. It must be him. Yeah, there are strict rules about what you can say. So you go from being a suspect, we think you did it, yeah, to we accuse you, we are charging you with a crime. Then you become the defendant in the case. And then you're either found not guilty and released, and you are innocent, or you are a convicted criminal. It's no longer an allegation, you are a criminal. The criminal procedure rules, I mentioned to you that the civil procedure rules were a very good starting point if you want some good legal vocabulary on specialist areas of civil procedure. The same with criminal procedure. You know, if you have to write some advice on evidence, cross-examination, look at the criminal procedure rules.